we're going to shift gears a little bit from what was a little more conceptual and overarching to something much more practical, kind of the nuts and bolts of what we as judicial officers do. You know, the thing about the internet is that, of course, it's a platform, and it is unprecedented in its ability to facilitate global, not just communication, but commerce. So how many of us have been on Amazon or eBay? And therefore it affords persons, people, power to do what? To be anywhere in the world at any time, transacting, interacting, communicating, publishing, entertaining, you name it, it's being done. Well, what are the implications for litigation? And what are there cases from around the world, from our region, our hemisphere, that speak to internet-related issues? This, in a sense, is maybe an emerging area, but certainly it's an area that's not going to disappear. We're only going to get more questions, more issues, more litigation around it. Adrian already averted to one example of when is a court a court. Does it depend on where it is? But there are many other issues. And to help us navigate this is Justice Margaret McKeown. She is, Margaret, if I may, a judge of the US Court of Appeals for the Ninth Circuit. She was appointed there in 1998. Her undergraduate degrees were from the University of Madrid and then the University of Wyoming. She did her JD at Georgetown University Law Center and actually has an honorary doctorate from Georgetown. Notably, she was a White House Fellow in 1980-81 and in 1993, a Japan Society Leadership Fellow. Before joining the bench, Margaret specialized in intellectual property and antitrust law, and has been, or is, I should say, on the board of the World Justice Project, on the Executive Council of the American Society for International Law, on the editorial board of the Litigation Journal. She's adjunct professor at Northwestern University Law School, and she serves on the Chief Justice's Workplace Environmental Working Group. Already you should be overwhelmed. Well, to add to it, she is the author of a forthcoming book, Citizen Justice, The Environmental Legacy of William O. Douglas. She has lectured and taught extensively in constitutional law, international law, intellectual property rights, human rights law, ethics, litigation, judicial administration, and done it globally, Latin America, Asia, the Middle East, and Europe. Published extensively, including most recently, beginning with Brown, Springboard for Gender Equality and Social Change in 2015, and in 2020, My Mother Made Me Do It, Short History of the 19th Amendment. Well, I think we're in for a treat. But before I hand you over to Margaret, the most important detail in her entire CV is this. Margaret was a member of the first American expedition to Mount Shishapangma in Tibet. And I hope, Margaret, you at least take one moment to tell us about that as we journey up the mountain, the internet mountain and its intersection with law and litigation. Please welcome Margaret.
Well, thank you so much for that incredible introduction. It's really an honor to be here. You know, this very first forum on judging the internet. I want to give my thanks to Aaron and also the Caribbean Agency for Justice Solutions for the foresight in blending these topics of the judicial role and the technical issues along with the social ramifications. First, an obvious disclaimer. I'm a judge from the United States, And so my perspective will be on cases from the United States, but we all share a common law tradition. So there is much in common. And as mentioned, I've done a lot of work around the world in rule of law issues and have had the privilege to work in the Caribbean. And for many years, I served as chair of the American Bar Association Rule of Law Initiative for Latin America and the Caribbean. So this morning, I want to set the stage for the development of internet law as we now know it, and then take you on a very quick trip to highlight some emerging issues. You know, this topic is so expansive. We cannot do it justice in this short time. It would take really days, weeks, and months. But all of us have a busy docket, and I know we have to get back to work. So I'm going to try to give you a flyby trip on these internet issues. Speaking of which, I do want to mention my jurisdiction and why the internet is so important to us. We are the Federal Appeals Court for the Western United States. And that means all the way from Alaska in the north to the Mexican border in the south, out to Hawaii, Guam, and the Northern Mariana Islands. And in our jurisdiction are these many companies that you read about: Microsoft, Twitter, Facebook, YouTube, Google, and Amazon. And although they are physically headquartered within our jurisdiction, I suggest to you that they too are in your jurisdictions, which is something that we'll talk about. And this is the reason that we are often called the digital circuit. But before we get into some of the specifics, let's go back in time and situate the internet in our lives. We need to recall that really the first public and broad use of the internet wasn't until the mid-1990s. Now, I unfortunately can't see all of you, but I would suspect that many of you might have even been children at that time. And so interestingly, the first time we saw the word internet in any decision wasn't until 1991. But it wasn't until later that our US Supreme Court really had its first real case involving the internet, and that was 1997, which isn't that long ago. And that was a case involving a statute to protect minors from explicit material on the internet. Well, that was really just the beginning. So if I go back and look at what kind of cases did we have before the year 2000, in the entire United States, both federal and state court, we had only about 300 cases. So now fast forward to about 2000, and we have so many cases, tens of thousands of cases involving the internet, that the legal search engine literally can't even compile all of those for me. So it takes me back, because before I was a judge, I was a practicing lawyer, and I represented Amazon at its infancy. And I was in New York in court, and there the question was, well, who would buy a book on the internet? You can answer that question yourself. So of the first topics I want to touch on is the internet and international values. And as we heard from Adrian, that culture eats strategy for breakfast. Well, this is a classic case of culture. Obviously, the internet doesn't really know any borders, and national values are not necessarily international values. And while courts may not be the best forum to sort out some of these issues, the reality is that these cases do land in our courts. So I think the best case to illustrate this is called Yahoo France. In France, it's illegal to wear, display, and sell Nazi memorabilia. Something very well understood because of what happened in World War II in Europe. In the United States, by contrast, because of free speech, this kind of conduct is not illegal. So Yahoo, which you don't hear about as much anymore, but it had an auction site and they sold Nazi memorabilia, you know, helmets, insignia, uniforms. And the League Against Racism in France brought suit and said, this is illegal because you are selling to French citizens. Yahoo said, no, this is an infringement of our free speech. You can't do anything about this. Well, the court in Paris disagreed and issued an injunction and fines against Yahoo. Yahoo then went to the United States and tried to get the courts in the United States really to nullify the judgment. At the first step, the court said, you're right, this is a violation of free speech. Ultimately, the US proceedings ended because of procedural roadblocks. So in fact, that French court judgment and its fines stood. And here that national value prevailed over a multinational corporation that had operated via the internet and in fact operated in so many countries. And because of the reach of the internet, this collision of values could play itself out in so many arenas. We can think of abortion, for example, drugs, pornography, and gambling. Just a few of the areas where national values may not be the same in one country as in another country. Now, the Yahoo case also represents for me a second principle I want to touch on, and that is technology matters. It's a classic case of where the judge had never had an internet case before, but he brought in experts and he studied and educated himself. Think of the things he had to understand. He had to understand cross-border jurisdiction, intellectual property rights, options for filtering out French citizens from worldwide citizens, location monitoring, and more. And he did that very expertly. So in many ways, the internet's really no different than many other topics that we deal about. We can't be experts in every single subject, but we can read, we can go to seminars like this, and we do learn novel topics, and we can expect lawyers and experts to help educate us. When dealing with a new technology, courts often ask whether the technology is really new or whether it's more like something we knew before. As Adrian says, we often look back, not forward. The internet cases give you an opportunity to both look back. In other words, is this like something we knew before? Was the telephone like the telegraph, which is often called the Victorian internet? Is a cell phone like a computer? But we also have to look forward because there are new ramifications and there are new aspects of this technology that will matter in the cases you are judging. But like much of our judging, analogy does play a central role for us to understand exactly what technology is involved. And of course, courts are concerned not just with this case, but what is the ripple effect and the ramification of cases down the road if you rule in a particular manner. So let me give you just a couple examples of where technology matters. Some years ago, we had in our court a case involving file sharing. And this is where internet users were sharing music files. And you can imagine the copyright holders and the musicians were tearing their hair out because basically they weren't getting any royalties. Napster was a popular site for this. And so the record company sued Napster, saying this is a copyright violation, you can't do this. In ruling for the record company, the court was really faced with something it had never seen before. I mean, this was all brand new. So if you look at the decision, our court went through a variety of analogies. If I copy your music file, is that like copying a book wholesale for redistribution? Is it like taking articles and photocopying them? Or is it like taking a radio broadcast, which might be copyrighted, and sending it over a telephone line? So the technology mattered, and the court had to think about where does that fit? But the court also will need to push some boundaries because there had been no case like that. And as we move forward, you're going to see more and more cases where there is no case like that. Another example relates to domain names. A good example was a company called Booking.com, where we can book flights and hotels and various travel adventures. Of course, nobody's going anywhere right now, so we're not booking any hotels, flights, or travel adventures. Because if we were, I would be there with you in person and we would all be gathered in one place, but we aren't. Anyway, Booking.com, back to the topic. Booking.com, the Patent and Trademark Office said, well, that's just generic, it's nothing. It's like saying fishing or finedining.com. But Justice Ginsburg, who wrote for the court, said, no, you're wrong about that. There's something unique about internet domain names because, in fact, only one internet domain name can occupy an identifying place on the internet. And that's not the same as just a regular generic term. So she invoked really the architecture of domain names and the internet to help guide through this particular decision. The third area I want to touch on is jurisdiction in the internet world. Really, the internet has upended our view of jurisdiction. You often read or hear talk about cyberspace. Well, we know cyberspace is not really a place, but it's an environment in which computers talk one computer to another. But there's no centralized government or rules. It's not a country. We know Belize is a country. We know Barbados is a country. We know all your other countries in the region are actual countries. But within the internet, this traditional concept of a country, which kind of has fences around its borders, really has changed dramatically. Now, in the United States, we can't take jurisdiction over a person or a company unless there's some legitimate connection with the United States. So there has to be, under our due process principles, sufficient context. Well, what does that mean in the case of a company operating on the internet? Because the headquarters might be in Ireland, for example. The server might be in Eastern Europe. The hackers might be in Russia. And the victims might be in the United States. So do we have jurisdiction or not? I have to say this is one of the most confused areas of law in the United States right now, but it's something we need to think about. And we contrast that with other countries, for example, Germany, where it has a law that says if there's a website accessible by Germans, then the internet service providers have certain obligations. Well, that's practically universal jurisdiction because there's hardly a website in the world that's not accessible by German citizens. So you can see these questions of where is the server located? Where is the victim located? Where's the company located? Are not particularly easy to answer in the case of internet jurisdiction. And as a result of that, you know, the internet has brought us some wonderful things, and it's also brought us some downsides. So in that regard, I want to briefly discuss social media and free speech. When we think of social media, we can think of Facebook, YouTube, WeChat, and many others. And as mentioned, half of humanity, 4 billion people, are active on social media. And that is mind-boggling. Now, in the United States, very few federal judges are active on social media. But that doesn't mean that social media is not talking about our cases, criticizing us, and in some cases, threatening our security. So social media has a lot of positive aspects, of course. It connects people in a very new and refreshing and different way. There no longer are these traditional gatekeepers to communications like an established media outlet. There's citizen-to-citizen communication. That's a positive thing. And also, there are some checks on disinformation. But the downside, of course, fake news, hate speech, bullying, mental health issues, and of course, the blurring of our private and our public lives. Now, in the United States, we have very little direct regulation of speech because of our free speech principles. So in the case of social media, this regulation is left to the platforms themselves, like Facebook and Google. And that raises a number of very serious and important questions. Should online speech be policed? And by whom? Facebook, the government, some nonprofit organization? Is the social media platform itself the appropriate one to regulate? And if so, who is it that's going to decide what kind of speech is harmful? Now, your first thought is, well, those are policy questions left to the executive and the legislature. And I agree, but the reality is those cases are in our courts, and the policy implications of our decisions are made through judicial decisions, not just legislative or executive proclamations. Now, when we think about free speech in social media, it really runs the gamut. There's one case came out of our Supreme Court involving a cheerleader. She was a very unhappy young girl because she had not made the varsity cheerleading squad. And so she said some very choice things, which I won't repeat here, because they're the kind of things that in judicial opinions we go like F, ... etc. She was mad at the school, she was mad at the cheerleading team, she was mad at the principal, and they suspended her from the squad for a year. But our Supreme Court said, no, free speech rights exist on social media just as they do in an auditorium, in a school speech, or somewhere else. On the other hand, there are some limits. So for example, when a defendant in a criminal case claimed that he had the right to publish these rap lyrics, which went after and threatened the very police officers who had investigated him, the court said, halt. There is a limit to free speech. And when you get to true threats, that's a limit. But of course, the limits between a threat and a disgruntled teenager is a very big swath of space that we have to deal with in the courts. So those issues of social media, whether they're intellectual property or free speech, or whether they implicate criminal law, are really coming to us in droves. And there's no stopping now as to the limits of social media and whether and how that speech is moderated is something that I think we will see more and more in our courts. Which brings me then to the question of privacy. You know, amazingly in the United States, we do not have a comprehensive privacy law. And people are often very surprised about that. We do have under our Constitution the right to be free from unreasonable searches and seizures by the government, and the right to have protection of our papers. But I contrast this with other countries, particularly in Europe, where they have very, very detailed privacy regimes. So the internet complicates this because once you put something onto the internet, like your private papers, or somebody steals your private photos, or they put identifying information, such as your government social security number or something else, it's very hard to get that back. A court can order a takedown of that information. But how good is that? Because by the time it's on the internet on one site, it's probably been replicated globally on multiple other sites. So we have to realize in the courts when we're talking about privacy and we're talking about the internet, that we're talking about something very, very different than our former conception of privacy. Because many of these internet sites are in multiple locations. The owners might be in Russia, Ukraine, or China and other countries, far beyond the reach of any domestic court. So court orders would often do very little good in these particular situations. Now, of course, the internet companies have privacy protocols in their terms and conditions. So when you sign on to shop on Amazon or somebody goes on YouTube, you accept by default their privacy protocols, but they change all the time and nobody reads that. So when they say to you, do you accept these terms and conditions? And you want to get going to buy the book on Amazon, or maybe you want to watch a rebroadcast on YouTube, you just go, yes, yes, yes. Nobody reads that. So the reality is that privacy has taken on, or lack of privacy has taken on this new dimension on the internet. And that, of course, also implicates criminal law. Just another example I'll give you. Because the internet's really changing the way that we live. More of our lives are digitized. And as we carry around cell phones or iPads, we're often being tracked. We're constantly visiting various websites that attach cookies or little trackers. So even if you think you're shopping in the privacy of your home, or you're communicating in the privacy of your home, the fact is that you are being tracked online. And the result of this is it also changes the way criminals do business, and it has changed the way that law enforcement does business as well. We had a case here in the Ninth Circuit about a gentleman who was bringing multiple computers across the border from Mexico. There's nothing illegal about that, private computer. But he had an alert out because he had multiple convictions for child pornography. And so the question there was, could the people at the border search his computers and do a forensic analysis? And in that particular case, which I wrote for the court, I pointed out that in reality, laptop computers, iPads, and the like are both simultaneously our offices and our personal diaries. They contain the most intimate details of our lives, financial records, confidential business documents, medical records, and private emails. And it implicates the right of our citizens to have a guarantee of right of privacy in their papers. But nonetheless, I wrote on behalf of the court that you can't indiscriminately search these computers, but if you have a reasonable suspicion, as they did with the child pornographer, then of course it would be legitimate to do that search. And likewise, as you use your cell phone and you drive around wherever you live, your cell phone is communicating with cell phone towers. And that's so that the service can go in uninterrupted. And those little pings from the cell phone towers can help law enforcement, for example, see where your movements are. Our Supreme Court has said that you need a warrant in order to track a citizen's movement using the whole constellation of these cell phone towers. And you can be sure that 200 years plus ago, when our Constitution was adopted, the founders had no idea about the internet, let alone cell phone towers. So I will go back very briefly, because you asked me to, about mountain climbing, because it is a good analogy in that we are really scaling up, that is the judiciary, to get ourselves into the world of the internet. Around us, citizens, particularly younger ones, are totally steeped in both the technology and the use. But like many new things, there are also hazards. So when I went to Tibet with the first American team to climb Mount Shishibangma, which is a 8,000 plus meter peak, 26,000 plus feet, it was a new challenge. However, I ran into one of the pitfalls. Like the pitfalls of social media, my pitfall was an avalanche. And I saw my life pass in front of me. It was totally scary to be bundled up in snow that was like concrete. And I really wondered if I would ever see the light of day. But I was fortunate enough. And that's a gift that I thank God and others for every day, that I had my adventure, but that I came out of it. And you can be sure when I went to China for that trip, this is in 1981, I had no idea that I would be in an avalanche. Now I'm in an avalanche of paper or an avalanche of information. And I guarantee you it's a much safer place to be. So in concluding, I'll say that the internet really has been a game changer for the courts. And I've only given you a few highlights of areas where we're seeing these issues. We need to understand not just technology, but also the shifting attitudes and behaviors that affect us, our countries, our citizens, and the internet. And we need to inspire public confidence in the courts. by addressing these issues with enthusiasm, not fear, and with an open mind, knowing that, like the internet, our decisions will have a ripple effect in the years to come. It's been my privilege to be here with you this morning, and I look forward to our dialogue. Thank you.